How do you name a successor agent for your power of attorney? Imagine you're setting up a plan to keep your affairs in order, just in case you can't make decisions someday. Choosing a successor agent is a key part of that plan. When you create a power of attorney, you pick someone you trust to handle your financial or healthcare decisions. But what happens if that person can't serve when the time comes? That's where successor agents come in. Start by clearly naming your primary agent in the document. This is the person who will act on your behalf first. Then, you list one or more successor agents in the order you prefer. These are the backup choices who will step in if your first agent is unable or unwilling to act. It's best to name multiple successors to avoid delays or court involvement. Choose people you trust completely, who are available and understand your wishes. Talk with them beforehand so they know what's involved. Make sure the power of attorney document states whether successors have the same authority as the primary agent or if their role is limited. When naming successors, it's important to specify the order of their authority. For example, if your first successor can't serve, then the second takes over. Avoid naming multiple agents to act at the same time unless you have clear instructions. Having them act sequentially keeps things simple and avoids conflicts. Once you've completed your power of attorney, give copies to all agents and inform family members or your legal advisor. If you change or revoke the document later, make sure to destroy old copies or mark them as revoked. In elder law, naming successor agents helps ensure your decisions are handled smoothly if you become unable to act. It keeps control in your hands and prevents the need for court guardianship, which can be costly and slow. To sum up, you start by identifying your primary agent in the document. Then, list one or more trusted individuals as successors in the order you prefer. Clearly state their roles and conditions. Finally, share copies with your agents and keep your documents updated. This way, your wishes are protected, and your affairs will be managed seamlessly if your primary agent can't serve.